Welcome to the sixth event in the public lecture series on the Wisconsin Idea, past and present. This lecture series is part of a new course that is being taught. This lecture series is part of a new course that is being taught for the first time under the auspices of the Sociology Department at the University of Wisconsin-Madison. Chad Goldberg regrets that he cannot be here tonight due to the observance of a Jewish holiday. I am Michael Masolia, Rams Professor of Sociology at the University of Wisconsin-Madison, and I will introduce tonight's speakers and moderate the question and answer after the lecture. Chad prepared a few opening remarks that he asked that I read before the start of the presentations. The Wisconsin Idea has always been about more than training students for the workforce. It meant, as Adlai Stevenson once put it, a faith in the application of intelligence and reason to the problems of society, the aspiration that the light of Wisconsin citizens and government be with the best torches of knowledge and understanding that our university can provide. Accordingly, this lecture series and the course with which it is associated aim to bring the students, staff, and faculty at the University of Wisconsin system into a broad conversation with the citizens of the state about how the knowledge produced at the University of Wisconsin has benefited the public in the past and will continue to do so in the future. I encourage you to participate actively through our course website, www.wiscidea.com, and our Facebook page. If you are live tweeting about this or subsequent lectures, please use the hashtag WiscIdea. The Sociology Department is offering this course on a shoestring out of our academic supplies and expense budget. If you would like to contribute to this project or allow us to offer real-time broadcasts or otherwise improve the offerings this semester or in the future, please consider making a contribution to the Department of Sociology Annual Fund, which you may do through this course website. We are fortunate to continue our lecture series tonight with a panel discussion on criminal justice in Wisconsin, featuring Michelle Levine, Pamela Oliver, and John Chisholm. Like all of our speakers, they are graciously donating their time and expertise free of charge out of a commitment to the public service. First, Michelle Levine is a distinguished clinical professor of law at the University of Wisconsin-Madison. Before joining the law school's clinical faculty, she practiced as a public defender in Madison. She now teaches criminal law, professional responsibility, and trial advocacy. She is also the director of the Remington Center's Public Defender Project. During most of her tenure at the University of Wisconsin Law School, Professor Levine has been involved in research and litigation on the rights of deaf defendants. Based on her advocacy for the deaf community, she received the Distinguished Member of the Year Award from the Wisconsin Association of the Deaf in 2005 and the Thomas G. Cannon Equal Justice Medal from the Legal Aid Society of Milwaukee in 2009. Professor Levine is a member of the faculty of the National Criminal Justice Defense College and the Wisconsin Public Defender Trial Skills Academy. She has given presentations to defense attorneys around the country on trial advocacy, and in 2010, she received the David Nablack Award from the Wisconsin Association of Criminal Defense Lawyers for service to the indigent. Pamela Oliver, my wonderful colleague, is a Conway Bascom Professor of Sociology at the University of Wisconsin-Madison. She is well known for her work on collective action and social movements and has published numerous influential articles in a book with Jerry Marwell on these and related topics. She has received multiple grants from the National Science Foundation and has served on the National Science Foundation's Advisory Committee. Professor Oliver serves on the boards of several nonprofit organizations and community advisory committees concerned with criminal justice issues, and she has made dozens and dozens and dozens of presentations to public officials and general audiences on issues related to racial disparities and imprisonment in Wisconsin. Because of her leadership in the area, she was asked to serve on the governor's special commission to reduce racial disparities in the Wisconsin justice system. She played a major role in helping to draft the report it issued in 2008 and was one of the lead authors along with her collaborator, James Yoakum. She served on Dade County's Racial Disparities Task Force in 2008, 2009, and continues to work with public officials and nonprofit groups in Wisconsin concerned about these and related issues. Finally, John Chisholm is a graduate of the University of Wisconsin Law School and the District Attorney of Milwaukee County. He was elected in 2006, replacing his mentor and the office's longtime incumbent, Michael McCann, after his retirement. Mr. Chisholm was elected in 2008 and 2012 without opposition. Mr. Chisholm is a national leader in criminal justice reform. He was instrumental in establishing the Drug Treatment Court in Milwaukee County. This court is specifically designed to treat the underlying issues that bring defendants into the criminal justice system. Through his establishment of the Public Integrity Unit in the Milwaukee County District Attorney's Office, he has played a key role in holding public officials accountable for their actions. He has served as the chair of the National Association of Prosecuting Attorneys and as a member of Governor Jim Doyle's Racial Disparities Oversight Commission. Mr. Chisholm based his career on the principle that the success of a prosecutor is not defined by just the number of people that he locks up, but more importantly by addressing the larger social issues that are related to criminal justice involvement. Please join me in welcoming all of our speakers tonight.
Thank you. How's this working? Is it working? Okay, thank you for coming out on a very nice Tuesday night when you could be home having some fabulous food. When I talked to Patrick Brenzel about this, it was pretty easy to come up with the title, Criminal Justice in Wisconsin, the Good, the Bad, and the Ugly, because it is all of those things, and it has been all of those things. Let's see, is this working? Let's see, which way do I press it? Do we know? Anybody know? Left? Do I want it to go forward? How about up? Nope. No? Well, now let's see how we're doing here. Let's see. It's this one, not this one. We'll try this one. I am at heart a trial lawyer, so this stuff happens all the time. It's like, yeah, fine. All right. So I came to Wisconsin in 1978 to be a public defender, and I never left. And I probably still am a public defender at heart. John will tell you that. He's laughing. But I just get paid by the University of Wisconsin now, and I'm very, very lucky for it. And as I thought about this, I thought, how in the minutes that I have up here do I begin to explain the good, the bad, the ugly about the criminal justice system? Pam's going to talk about some of the ugliness. John's going to talk about some good things that he does. And my job is to kind of give you an overview. And what came to mind was this poem that I vaguely remember from when I was a little kid, although I never knew Longfellow wrote it. Is this working? There it is. There was a little girl who had a little curl right in the middle of her forehead. And when she was good, she was very, very good. But when she was bad, she was horrid. And when Wisconsin leads, and when Wisconsin has been true to its motto, forward, we've been very, very good in criminal justice. And when we haven't, when we've followed, when we've gone with the pack, we've been somewhere between middle of the road, and I'm sorry to say it, horrid. So let's start with Wisconsin leads. I just want to give you, I love these facts about Wisconsin. And early in when I first got here, I thought, God, what a cool place. What great things they're doing here. Look at this. Death Penalty Repeal Act, 1853. The right to appointed counsel for indigent defendants, 1859. The famous case of Gideon versus Wainwright was 1963. Look what the Wisconsin Supreme Court said, and would it not be a little like mockery to secure to a pauper these solemn constitutional guarantees for a full and fair trial on the matters with which he was charged, and yet when say to him on trial, he must employ his own counsel, who could alone render these guarantees of any real permanent value to him. That was over 100 years before Gideon versus Wainwright. And from that time, it wasn't in every case, but I will tell you, judges in Wisconsin appointed counsel and paid for it in felonies. And then we have this, 1975, the Youthful Offenders Act, where they talked about individuals under 21, and under that program, they said, we recognize you're not formed, you're not an adult. This is 1975, and they're talking about people under 21, and those of you who are parents know that, adulthood does not begin at 18. Individuals are in their formative years with an adult lifetime ahead of them. That law was in effect when I came to Wisconsin. It has since been repealed. What are some of the good things that have gone on at the University of Wisconsin? because a lot of what's good about the University of Wisconsin, about Wisconsin criminal law, frankly, comes out of the law school. We are a criminal law school. In 1949, Frank Remington sat down with the Legislative Council and said, you know what? We can't have a bunch of a crazy quilt of criminal laws. We have to start having a code. We have to have a system. Nationally, people started to recognize, and they came up with the model penal code. Again, let's get away from this crazy quilt. Let's have criminal laws that make some kind of sense. In 1956, he drafted the Wisconsin Criminal Code. We then came up with uniform jury instructions, so it wasn't a judge just getting up there and saying, well, I think the law means this, jury. And in the 1980s, again, there were revisions and they were comprehensive. He just wasn't, picking up apples and slinging them at the wall. It was a code. For those of you who are interested in policing, one of the gods of police reform is Herman Goldstein. In 1977, he wrote Policing a Free Society, in which he talked about problem-oriented policing. That it isn't just about law and order. It's not just about getting the bad guys. That look at all these things. That it's about maintaining a sense of security, protecting civil liberties, facilitating the movement of people and vehicles, assisting the vulnerable, and resolving conflicts. And if you're wondering whether that's still current, a couple months ago, the New York Times wrote an editorial piece advising New York that after William Bratton, the chief of NYPD, that after he had retired, that one of the things that New York ought to be doing is looking at the work of Herman Goldstein. To start to realize that it isn't just about the bad guys. Now we're at something else. This is not Wisconsin's finest. This is the state prison population in Wisconsin. And I like this because it starts in 1978 when I started here. Look at the prison population. It was about 4,000. That's 4,000 in 1978. 2011, it was about 21,000. As of September 30th, 2016, it was 22,500. So I don't think that's anything to be proud of. And you can see the dramatic results. Now I will tell you some of the things that were going on nationally. War on drugs. The war on drugs, we picked that up as you see it start to go up in the 80s. We were loving the war on drugs, just like every other state. The feds came along with the federal sentencing guidelines, and they're in 1987, and their prison populations looked exactly the same. We had our own thing, and this was in 1999. We began Truth in Sentencing. It was a sentencing scheme that was several years in the making. It was not in discussion with anybody from the University of Wisconsin. We had previously used indeterminate sentencing, and that's where the judge said, I'm sentencing you to 20 years, and you had to serve a certain percentage by law, but there came a time where the parole board could start to consider how's your behavior, and there came a time when they had to let you out to see how you did. And you would finish that sentence up, and if you succeeded, it was done. Well, we came up with a bifurcated system. So the first part is incarceration time, and it's a flat number. Now, if you get 20 years, it's 20 years. There is no parole board looking at you. Followed by a period of extended supervision. Well, the theory back at the time, I actually remember this, was that, well, judges will adapt. Judges will recognize that what they once gave as a 20-year sentence, now we have to make it look different in order to get the same thing. We have to give a 13-year sentence and then 7 years of extended supervision. Oh, no. Because it turns out judges really like the sound of 20 years, of 40 years. And so the incarceration period was not adjusted to reflect the lack of parole. This has led to an unbelievable increase in old inmates. The fastest growing population in our prison system is people over the age of 55. In addition, we were given lengthy periods of extended supervision. So that now, in addition to all these, remember the 22,500 that are on supervision or in adult prisons, there's another 60,000 on supervision in this state. We have the problem of increased criminalization and felonization. We've gone back to the crazy quilt. We've gone away from the Frank Remington model, and we're doing what Walter Dickey, another one of our stars at the law schools, calls the crime of the month. Well, here's something that upsets me. Let's quick pass a law. And I'm going to give you an example. Because I'm a trial lawyer, I like to use demonstrative. This sweet little book is the size of the statutes as they existed when I started practicing. There were 4 of these. Now there are 6 of these. And the type and the margins are pretty impressive. The criminal code back then was 58 pages. I'll give you another 10 pages for the Uniform Controlled Substances Act, which is not in there. In here, oh look, 130 pages. And then we start with the crime of battery. Back then, there were 3 kinds of battery, a misdemeanor and then 2 levels of felony. And then there were a few special circumstances. Inmates, don't go battering somebody. Battery to a police officer, battery to a judge, and battery to a juror and to a witness. We now have, let's see if I can find some of these. Battery to technical college district or school district officers and employees. Battery to bus drivers and bus passengers. Battery or threat to a Department of Revenue employee. Battery or threat to a Department of Safety and Professional Services or Department of Workforce Development employee. Battery to certain employees of counties, cities, villages, or towns. Those are all felonies. All of them. And we have with that the fact that a couple months ago, John and I were talking about this, a prosecutor who I know came to the Capitol to testify before the legislature about the need to make it a felony to commit a battery against a prosecutor because a defendant had spit at him. And I'm thinking, great, so you got it's a battery, it's a felony against a judge, the clerk, the witness, the juror, and the DA. Who's sitting out there? Who's sitting out there? It's not a felony, I guess whatever they want to do to me. We have great prosecutorial discretion, and it varies from county to county. The example I give, small amounts of marijuana, under an ounce, in this county is treated as an ordinance, a traffic ticket. In Columbia County, first offense is a misdemeanor for even small amounts. Second offense is a felony. Judicial discretion, same thing. John and many DAs are doing some great stuff, but there's judges who will say, I don't buy it. I'm not going into it. I'm going to run through this really quickly. We've also basically, in 1996, we bought into the super predator idea, that kids are super predators, and we basically went from kids are in court at 18, in adult court at 18. Now it's at 17. Certain crimes are age 10. It's a lower waiver age. You are delinquent. You were brought into the delinquency time at age 10. And one of the things we've seen is a spike in some extraordinarily long sentences for children. Because I'm sorry, when you're 15, you're a child. I will say the Wisconsin idea does still live. Whether we're talking about recording interrogations, we're front and center on challenging the orthodoxy on shaking babies. A lot of work with the University of Wisconsin, with police departments, and with policymakers on police procedures, post-conviction DNA. This is how the Innocence Project operates. They get DNA from somebody in a case that's been closed, and you got the wrong guy. Increased compensation for exonerees. Wisconsin has the lowest rate of compensation in the nation. It's currently $5,000 a year, up to $25,000 max. Tell that to somebody who's done 25 years for something they haven't done. We're involved in the United States Sentencing Commission, and yeah, I do have to get myself involved here. Okay, I'm going to toot my horn for 30 seconds here. I do work with the deaf population. I also work a lot with language impairments, and I do a lot of training of defense attorneys around the country, explaining why so many of our clients have a really deficient language skills. You want a good example of it? Those of you who saw Making a Murderer, Brendan Dassey. That kid, everybody talked about he had disabilities. His disabilities were in the verbal realm. I've seen the numbers, and they're absolutely shocking. That kid had stunningly low verbal skills. And I want to end with this. I want to show you something that I came across. This was done in 2010. This is the Wisconsin Model Policy and Procedure for Eyewitness Identification. Came about because we've discovered that there's a whole lot of social science about eyewitness identification and how eyewitnesses are wrong, and it's volumes and volumes and volumes of information. And people at the Innocence Project in particular have looked at it and worked on it. This was put out by the Wisconsin Department of Justice. J.B. Van Hollen was the Attorney General at that time, and this is what sits at the very end. Just as other products of this partnership have improved the state's criminal justice system, these policies and procedures are designed to bring to bear the best techniques for the collection of eyewitness evidence. Thank you.
Well, I usually speak for an hour, but I like to, since John Chisholm was gracious enough to come all the way over from Milwaukee, I want to keep myself to 10 minutes. And I'm going to show you some stuff that you cannot actually digest in 10 minutes. But I just want to show you the kind of thing that I do. And my usual protocol has my laptop in front of me, so I don't have to turn my back on the audience to look at the screen. But I just want to give a short example because I view the work that I have been doing as trying to exemplify the Wisconsin idea in my own small way. I personally got involved in the issue of racial disparities in incarceration in the year 2000. As far as I know, I was one of the first to start calculating these race-specific statewide incarceration rates and producing rankings and stuff. Lots of people got in the game, so I'm not sure I was first, but I was certainly one of the first people working on that. Since then, I've given over 100 public lectures on the topic, and I've been in a lot of groups that was talked about. One of the things that actually happened in 2006 is I'd been debating with Mike McGann, the former district attorney in Milwaukee, a few times. And in 2006, Mike invited me and John Chisholm to have lunch in a coffee shop, and I actually gave them a personal presentation of my PowerPoint show on a laptop in a coffee shop. I like to think that maybe that had some impact, although I think the data kind of show the reforms were actually already happening before that meal. I was on the Governor's Commission, Dane County Task Force. My specific focus is bringing data to bear on questions, really trying to drill down and understand where and when and how disparities arise in particular places. One of the things that I've learned is that each place is different, and so broad generalizations are Dane County is really different from Milwaukee County, is different from Kenosha County, et cetera. Each place has its own particular patterns. And I really believe in holding systems and institutions accountable by making data public. Early on, you'll see we had a really big emphasis on the drug war, and the charts will show you that emphasis on the drug war had an impact. And as time has rolled on, the treatment of people on probation and parole has become more important. It's important to remember that there's discretion, and you might want to start using the pointer. I usually control my own pointer, but there's discretion in the system. So this is just a reminder that who goes to prison is a product of a large number of decisions. Starting at the top, there are kind of somebody made the decisions that contribute to the social conditions that might affect people's tendency to commit crimes. Then there's crime. Then there's the policing decisions about arrest. Then if the person gets arrested, the prosecutor makes some decision about charging, and then there's the judicial sentencing, then the person goes to prison, then the probation parole board gets involved in whether the person goes in or out. So there's a lot of stuff going on. And I just made this slide to emphasize that the part of the process that John Chisholm's been involved with is the prosecution process. And what I did, I ran some new graphs. I've got some updated data. I'm just producing it in the last 3 weeks. I've been having a lot of fun. And I put a vertical line. Well, you'll see, I've been focusing on what changes happened in Milwaukee since John Chisholm took office is kind of a way to focus our attention. First, I just want to remind you that I'm looking at prison admissions in these slides. There's the stock of who's in prison, and then there's the flow of who goes in and out of prison. And those give you different numbers, and I don't have time for like the 10 minutes of showing you both. But these are prison admissions I'm looking at here. And what this is, so the important thing to see, and pointing at the top line, the top line is everybody who goes to prison. That includes going back to prison on a revocation from parole or mandatory release or extended supervision. Down at the bottom shows up in the records as a new sentence without a revocation. And then the middle line is somebody who got a new sentence and a revocation. So you can see most of the prison entries are people coming off revocations, not new sentences. And then this is just this overall statewide black-white disparity in imprisonment by the 3 types of admission. And basically what it's showing is that the racial disparity in prison admissions has declined from about 18 in 2000 down to about 9 in 2014. So there has been a decline in the disparity. Now, looking at Milwaukee, so I just want to, the reason I'm showing you, this is what that pattern looks like for Milwaukee. And the next few slides I'm going to show are basically broken out by offense for that middle line. That is, it's new sentence, either with or without a revocation. There's a lot of ways you could do it, but this is the way I'm doing this slide. And I will say it's broken out by offense. This is a record from National Corrections Reporting Program. It's column 1, the offense with the longest sentence. This is not necessarily the most recent thing that you did, but it's the way you normally break out offenses from these records. Now, this is the slide where my tech support's going to help. So this is black, only black people, the offense of what the new sentence was. And obviously the big story in this picture is the top line is drug sentences, and the steep decline in drug sentences as the offense category for new sentences. That's the big story out of Milwaukee. What else is in there? So the second, that green line that says ASS is assaults. That's kind of holding pretty steady. Robberies, the red line, that's holding pretty steady. This bright green line is actually weapons offenses. Kind of a surprising thing. I don't know if it's weapons enhancer or whatever, but for a lot of people, a weapons offense is their governing offense, and that's got a steep roll in there. And then property crimes came down, and then there's some other stuff down in the change. Homicide as a basis for prison admission is in there. It's this kind of brown line in there. So this is just to give you a sense of the mix of crimes for which black people go to prison. Okay, this is, now we're going to do it for whites. Same thing, a little different mix. It's a really different pattern. So first, if you would highlight the drug line for people. The drug line is in the pack. It went down, and then it actually came back up in Milwaukee. Now, what's at the top? So that green line that starts at the top and then goes to number 2 there is assaults for white people. And then number 3, that what's ending at the top is DWI, and there's a steep increase in DWI. It turns out what white people go to prison for is drunk driving, actually. And it's the offense category that's actually a white crime. And then we see a steep decline in property offenses, and there's some other stuff in there. The white incarceration rates are much lower than the black rates. Again, you don't really have time to digest this. I've actually got this stuff on my website if you want to go there. Okay. Then I calculate the black-white disparity by offense, like which offenses are most disparate. So Milwaukee, it's the green line at the top. The weapons offenses are actually the ones that are most disparate. Then you see this high disparity in the drug offenses, and then a steep decline over time. Robbery is kind of in there, declining slightly, holding pretty steady at 20 to 1. So notice how strong these disparities are. We're talking 30 to 40 to 1 for the drug offenses and for the weapons offenses in the past. Most of the offenses are down at the 10 level, so blacks are still 10 times more likely than whites to go to prison. But you can see that there's a big difference across offenses in what these disparities are. Way down at the bottom is DWI. There's basically no disparity in DWI. So that's kind of the pattern on disparities. As I said, I've got this information posted on my website. If you actually want to study it, you're going to have to look at the PDFs. Okay. We're in Dane County, so I'll just quickly show you what Dane County looks like. So this is all new sentences. So let's see. Let's trace the drug line. Again, Dane County showed that steep decline in drug sentences at the end of the 2000s and into the current decade. Assaults are high. Property offenses showed a steep decline. Robbery was holding kind of steady and then kind of went down and back up. Other offenses in the mix. As I said, I know you'll want more time to really study it. These are the white offenses. Again, you can see DWI in there for whites. Early in the 2000s, property offenses were, whoops. Oh, wait. There we go. Property offenses were a main reason for going to prison and then declined. And these are very low incarceration rates. Let's see. So the black-white disparity for Dane County is really, really high. Notice those numbers over on the side. We're looking at 80 to 1, 60 to 1. You know, even the lower ones are 20 to 1. The only thing that there's not this incredible disparity for in Dane County is drunk driving. Now, what I want to do, I will say on my website, I posted county comparisons. And for those of you who want to know, Dane County has a really high racial disparity. The counties that actually have the highest black incarceration rates are especially Kenosha and Racine, who also lock up lots of white people. So they have lower disparities, but very high incarceration rates. There's a lot more that you can look at. What I want to do is show you, this is an animated graphic. So notice up at the top, I've got Wisconsin, and this is going to go from 2000 to 2014, just kind of letting you see what's been happening with the incarceration rates over time. So let's make the graphic go. So notice how that Wisconsin is high, very, very high. 2007, 2008. Now Wisconsin's coming down, but notice so is the rest of the distribution. So yes, our black incarceration rates have been dropping, but so have other states' black imprisonment rates. So I do have these slides and more information in PDFs. Right now, I just put a lot of it up on my website, which is the Race Politics Justice blog, and then I'm adding it to my academic website as fast as I can. If you Google Pamela Oliver Sociology, that's probably the easiest way to find it.
That's great. Thank you very much. Good evening. It's a pleasure to be here. And I guess I would start by saying to both Michelle and to Pam, thank you. And it actually confirms a lot of what we've been aspiring for the last 10 years or so. So I'll give you a little bit of background on how this started. The National District Attorneys Association approached my predecessor, Mike McCann, in about 2004 or so, and said, look, Mike, you're one of the longest serving DAs in the country. We would like to approach you and two other long-serving DAs to consider starting a project that would be called Prosecution and Racial Disparity. And why were they approaching long-serving DAs? The answer was they acknowledged up front that there was a great deal of political risk involved in basically opening up your office for an outside entity to come in and take a look at how you process cases and making a determination whether anything that you do actually contributes to disparity in outcomes, whether that's in jail or in prison or in any other context. Well, it's interesting that was taking place at almost the exact same time. A gentleman by the name of Mark Maurer was conducting his own national studies on incarceration rates and disparities. And he released that information, I think in 2007 was when the Sentencing Project report came out. And we were getting inklings even before that, about a year or so before that things were not looking good in Wisconsin. And that Wisconsin was coming out as an outlier on incarceration rates. Now, we have to keep in mind that rates are just that. You're comparing the number of people in your prison system is not the you're not comparing the total amount of people from one state to another. You're applying whether or not there's a disparity within the admissions within any particular system. A lot of factors that go into that. And so obviously the elected DAs at the time were really reluctant to open themselves up to this. Another really important factor, and so when Pam and Mike and I sat down and discussed these issues, here's the other practical reality that we confronted. The Milwaukee County DA's office at the time, for all practical purposes, was still a paper-based system. Sure, we had some Excel spreadsheets that each unit ran to keep track of some of their cases, and you had some legacy systems in place right there, but you had no functional case management system in the Milwaukee County DA's office at that time. So I used to describe it as it really would not have been that different if you'd come into the office in 1968 versus 2008 before we were able to implement a case management system. So one of the principles that we followed early on in bringing Vera in, working after discussing it with Pam, was that you can't change what you don't measure. So you really have to measure what you're doing in some effective way to figure out if there's a problem. So first, what we did is we just allowed Vera to come on in and take a look at the data that we did have. And I'll be honest, this was not, at the time, because the data systems were so limited, it was just a straight up black-white comparison at that point in time. We didn't have a lot of really nuanced data on the either victims or offenders coming into our system. So this first study they did was just a slice. They took a look at all of our charging decisions from start to finish, and then they sliced them down and applied the appropriate methods of determining whether or not the disparity was actually there. And it's coefficients. It all gets very complicated at times. But bottom line is, once it comes out, it is what it is. It ultimately is what it is. And what we found in our office was that overall, the good news is this: is that our charging decisions were pretty even-handed. In other words, there was almost no disparity when you looked overall at the charging decisions by the Milwaukee County DA's office. That's great news, right? Well, when you then broke it down into individual offense categories, you saw a huge disparity. And the disparity occurred in places that you wouldn't be surprised by, particularly in the lower level drug offenses. That's one of them that we saw a major disparity in. Obviously, there were disparities in some of the weapon offenses. There were disparities. There were even reverse disparities, which was an important insight from our perspective as well. Reverse disparity being that we actually charged white offenders at a higher rate than African American offenders. And at first you'd say, well, that's good. That balances things out, right? Well, some of the experienced people in our office took a look at it. It was actually in property crimes. And so, again, some of our deputies saw that data and said, why is that? Is that because of some evening of the scales, or is it potentially because investigators and the DA's office and everyone else is devaluing victims of property crime that are coming from our central city? These are poor people. They're exposed to lots of crime. We're not putting as much effort into investigating those cases and prosecuting those cases as we might for some suburbanite who had their garage broken in, and you get a full-fledged investigation, results in identifying the offender, and you get the prosecution. So it was an important opportunity to really look at it from the perspective of what's really going on and what are the underlying dynamics. So that in turn led us, once we saw that slice, to start focusing in on that problem. So how do you address it? How do you actually operationalize it? That's the key issue in here. And so part of what we did is I can kind of show you, and I don't want to spend a lot of time, but what it basically meant is that we had to invite people in to show us how to approach things in an evidence-based way. And it doesn't mean, and I put the caveat in here right from the beginning, and I have to tell my own people this all the time, and that is that evidence is just that. It allows you hopefully to make better decisions, but it never overrides or takes away your ability to use professional judgment and your discretion and all of your experience and all the other information that you can bring in. But generally, your decisions will be better if you have more information available to you. That requires really a change in process completely. So starting in about 2007, one of the key things we did is establish a Community Justice Council. That's essentially all the key stakeholders in the community justice system, the chief judge, the police chief, the head of the public defender's office, myself. It involves the county executive, the mayor, the sheriff when he wishes to participate, and which is never. So that's an easy one. We do a lot of workarounds on that. But essentially, you have all your decision makers in the room. We meet on a monthly basis, and it was expressly stated that we would try to design and implement a better criminal justice system, one that was more effective, treated people much more efficiently, effectively, and fairly, ultimately fairly. And so there's a component of it that involves community outreach and changing those processes. So one of the first things we changed up was literally how we process people after they're arrested. What we developed, and we got the county to invest into about a couple $1 million to do this, was to dramatically expand pretrial services so that we could begin actually assessing people as they come in. So we invested the money. We now do what we call universal screening. Anybody arrested in Milwaukee County who is going to be detained, is going down to the jail, is going to be given an opportunity, and about 90 to 95% of them avail themselves. Obviously, if you're arrested for a homicide, we're not going to take you through this process. We're not as concerned about your risk score and things like that at that point in time. But the vast majority of people are going to be given the opportunity to be assessed by pretrial services and figure out why you're coming into our system in the first place. So that was the start of this process right here. The research basically just demonstrates that if you focus on risk instead and start going away from offense, and that's a sea change as well. So it really means you start focusing on the person that's in front of you and why are they here, as opposed to, well, look, this is the offense they committed, I can prove it, and here's their criminal record, and I don't care about anything else. It's whether I can prove it or not, and how many times they've done it before, and that's going to base every decision that we make from that point on. What we decided is we had to get away from that model. It's still appropriate in many cases, but what we decided is we had to get away from that offense-based structure and start going to a risk-based structure, actually identifying why people are coming to us and what we can do to intervene if we can intervene. So that was the start of the process right there. So we started a range of options. So we now have what we call pretrial diversion, which is in the world of Wisconsin Circuit Court Automated Program, which is CCAP. Everyone knows that. You don't go out on a date without going to CCAP first. The reality is that if you want to reduce the impact of system contact on low-risk individuals, then you have to come up with a system of actually diverting them in an accountable way out of the system right from the get-go, from the short period after arrest, allow them to be screened, allow them to consult with a public defender, defense attorney, give them the information they need to make a meaningful decision with their client. That's a change in process. That means you have to actually give them police reports and things like that as soon as you practically can. And then do the assessment on them and figure out if they're low risk and they pose no danger to the community, what would you rather do? Do you want to just tag them with a Class A misdemeanor because you can and get 30 days of jail on them or probation or whatever, and then just stack it up and then push them down the line? Or would you actually like to take the opportunity to intervene and actually divert them out of the system, and then they never show up in CCAP? They never show up in CCAP. So it's going to have the effect down the line. And now we've been able to do that with thousands of people since 2007. Deferred prosecution. Deferred prosecution is sort of your mid-level. So that's a person that may have had system involvement in the past. They're low to moderate risk, and they need a little bit more structure. So generally a deferred prosecution is also known as a deferred judgment agreement. Basically it says, look, I've met with my defense attorney. They agree that were we to try this case, we might not succeed, and we want to take advantage of this. We'll admit guilt. We'll defer the entry of judgment for 6 to 9 months, and during that time period, you're going to accomplish a couple core things that you really need to do to change your behavior. If you successfully do that, the case gets dismissed. That's our ultimate goal, is that you don't walk away with a conviction. Now, the downside of deferred prosecution agreements, I will tell you up front, is it still goes into CCAP, right? And so that's That's still a collateral consequence that we have to be aware of. What we have for those individuals who say don't succeed on the first try, or who we think are not appropriate for a deferred prosecution and are sentenced to a jail sentence, they're oftentimes eligible for what we call our day reporting center. So there's a host of programs available in the House of Corrections. Many of them are available out of the House of Correction itself and in a community setting where they're able to get education, treatment, and all of the services that we hope will modify the behavior and actually let them transition back into the community from the House of Correction. So it's not just okay, you did your 6 months, you dumped off at the front entrance of State Street with your bag of clothes and good luck. So what we really try to do is transition them back into the community in a more effective way. Drug treatment court. This was a tough one for me to understand, and that meant that drug treatment court was only for our high-risk offenders. That means people that oftentimes had lots of felony convictions before. And you know, when I first started this, I would have said, well, drug treatment court is for our low-risk offenders, so they don't get a conviction or something like that. That's not what we use our scarce resources of drug treatment for. They are for our high-risk offenders. These are for clinically addicted people who this is literally their last chance. So the deal there is that they have to enter a guilty plea. Many of them are facing prison or long periods in jail if they don't succeed, but we take a lot of time with them and invest a lot of resources. These programs generally last about a year to 18 months before they're graduating from the drug treatment court program. What's changed since we started? We were able to open our drug treatment court. We in Milwaukee were a little bit late in the game. We didn't start until about 2009 with our drug treatment court. And that's not to our credit by any means. But we had to overcome a lot of institutional resistance to that. That's just the reality. And so since then, it's been widely accepted. We've gotten good results with one caveat to that, and that is when we started that, in my mind, it was connected to reducing racial disparities as well. The vast majority of people coming into our system at that time were coming in for cocaine addiction, particularly crack cocaine. Starting about 2010, that dynamic changed completely. And nowadays, it's all about opiates. It's all about opioid addiction and the various forms of that. And along with that, the whole landscape has changed. For example, I now have a full-time prosecutor dedicated to nothing but Len Bias prosecutions because we went through one weekend where we had 18. Not just a weekend, it's like a 3-4 day period where we had 18 overdose deaths in Milwaukee County. So it's just changed. It's been a sea change. But that also has changed our demographic, believe it or not. So some of the data that Pam put up there, it correlates exactly with my experience right now. And that is, the fastest growing population, disparity-wise in the Wisconsin prison system right now is white middle-aged men. And they're not just from Milwaukee County, but from across the state. And that's because they changed the law to make OWI fourth now a felony offense in almost all cases. They change the OWI laws every 6 months. So it just, but now it's effectively for your fourth offense, it's a felony, and we're dealing with people who are on 6, 7, 8, and 9, and they are going to prison and going for fairly lengthy periods of time. So that's the largest growing group. The other thing that you can see, and again, consistent with our concept of the Wisconsin idea, and that means government officials actually working with and collaborating with academics and outside groups that are interested in improving systems, but just working in collaborative fashion with those and with other partners in the system, you can see results. You can actually see those results. So if you looked at those lines from 2006 on, you're seeing dramatic reductions. Is it only because of what we were doing? No, we benefited from a lot of things. And what I'd finish by saying, I can run through these real quick. I give this thing. That's just the line I talked about in terms of how we process people through diversions, DPA, day reporting center, drug treatment court. I forgot to mention, we do dosage-based probation now as well. That's sort of an experiment we do. What do we mean by that? We only give people the conditions that they need for supervision we don't stack up like 10 or 12 different conditions, many of them that are meaningless, because what that oftentimes leads to is they get revoked on things that don't really mean a whole lot, but they're extended until they complete certain things. So we try to reduce what they need to change their behavior to a short period of time. So that's really a bit it. These are the tools we use. I'm not going to go into a lot of detail about the types of tools we use to assess people. These are our goals. And I'll just run through those real quick. I'll make that available for you. This is more of the nuts and bolts of what I just explained right there. What I will tell you is this. Here's a distinction that you have to keep in mind. While we were implementing these programs, we saw the largest decrease in violent crime in Milwaukee County's about a 30-year history. So by about 2010, we had our lowest rates of violent crime that we had seen in Milwaukee since the mid-1970s. We are not there right now. We have seen a significant uptick since about 2015 in our violent crimes, and particularly in our homicides and our firearm-related homicides. What I want to make clear to you is that you have to make a distinction between what we're trying to accomplish on these types of interventions with the way we're trying to address violent crime. It was hard for me to understand this. It took me years of looking at this data before we figured out that the two just simply are not correlated. In other words, the way you can address people who are coming into the system who are low risk, moderate risk, and the clinically addicted is separate from the way you address your violent crime problem. And sometimes that leads to concerns as well. Pam pointed out one of them, the disparity in firearm sentences. What that reflects is a policy of mine. And you know, I've been accused of being soft on crime, all this nonsense. I've always taken a very strong position on the issue of firearm-related crimes. We have fairly strict policies, and we try those cases. Those generally are felon in possession of a firearm cases and cases related to non-fatal shootings, which are significant, right? So the difference between a fatal and a non-fatal shooting is a couple millimeters. We had over 650 non-fatal shootings in the city of Milwaukee last year. We had 148 homicides. 85% of those are firearms related. I take a very strong approach towards illegal firearm use in the community. And so that may reflect some of those disparities, quite frankly, because we recommend prison for those types of offenses, and we try them. So that's just one example. But I always try to keep a distinction between, because so much of our policy is driven by the immediate impression. And as a country, as a whole, we have to get away from that. The reality is that we went on this tear from 1970s on and have the highest incarceration rate in the world, but at the same time, our violent crime rates have gone up, they've gone down. They've gone up, they've gone down. Almost totally divorced from our incarceration rates. So we got to keep that in mind. I fundamentally believe that we have to take different approaches to the two problems, and that's a whole different lecture on how we address the violent crime problem, but that requires some significant change in process as well. But thank you.